My name is Michael Terasaki. I'm the Washington State Pro Bono Council Manager. Okay, there we are. And along with Caitlin Monaco, who's also here at the Pro Bono Council, we are in charge of running the Dementia Legal Planning Project for Washington State, which is funded by DSHS. Caitlin and I are based out of the Eastside Legal Assistance Program in Bellevue, but we work statewide to coordinate and support the 16 volunteer lawyer programs here in Washington. Our special guest expert here today is Professor Lisa Brodoff from CLE University School of Law. She teaches elder law, admin law, and estate and disability planning. And she was an important player in creating the Mental Health Advanced Directive and the Living with Dementia Mental Health Advanced Directives, and which we will cover that latter one today also. So before we get to Professor Brodoff, and I'm sorry, here's our slide for Professor Brodoff. This is a CLE and volunteer opportunity put on in collaboration with the Dementia Action Collaborative. And if you're not familiar with the Dementia Action Collaborative, or the DAC, it's a group of public-private partners committed to preparing Washington State for an increase of people living with dementia. The DAC is a really active group of medical providers, social service providers, lawyers, community members, caregivers, family members, and a big part of that work is carrying out the state plan for Alzheimer's disease and other dementias. Now, if you're already volunteering, hopefully this presentation today will give you a little more info. And if you're just thinking about volunteering, either with our Dementia Legal Planning Project, or maybe through a local wills or estate planning clinic, this presentation can give you some training on how to guide clients through the advanced planning process. The goal of this program is to introduce just the basics of how to help folks recently diagnosed with dementia or perhaps with a family history of dementia. And kind of the crux of this is this Dementia Legal Planning Toolkit. So before we dive into the kind of the nuts and bolts of the planning documents, I want to talk a little bit about the Dementia Legal Planning Toolkit, which is just one of the Dementia Action Collaborative projects. And if any of you know Meredith Grigg or Katie Denmark, they did a ton of work to put this together, and it's a fantastic tool. So big thank you to them. The toolkit is basically just a resource for people to find out more about kind of the basic steps for the basic advanced planning documents. It provides kind of a roadmap and some very specific forms, which Professor Brodoff will be covering today. And I think Caitlin has put some of it into the chat. It was also sent out with the materials. I'd encourage you to take a look at it. It's got a lot of great information, from real basics to, at the end, there are a ton of resources if people are looking for a deeper dive into some of the advanced planning documents that we're not covering today. Okay, so there's also some great checklists here. And like I mentioned, there are some forms included with it. The ones we'll be covering today are durable of attorney for finances and for healthcare. And these documents will also be sent to you in the materials, and they're also here in the chat link. The healthcare Advanced Directive and the Living with Dementia Mental Healthcare Advanced Directive. Some of you may have a lot of estate planning knowledge already, and a lot of this presentation today will be more focused on the basics, but I encourage you to stick with us for the hour because you may not know much about this Living with Dementia Mental Healthcare Advanced Directive, and that's a really great tool that we have here in Washington. With that, I'll go ahead and turn it over to Lisa Brodoff. Please take it away.
Great, thank you, and welcome everyone. I wanted to also say Happy Valentine's Day, and really there couldn't be a better day to do this kind of training because there's really not a more loving thing you could do than to help someone express their values, their hopes, concerns, and do this kind of planning for themselves and their family members and loved ones. So today's a great day to take this training, and I hope you all do volunteer to do this for people who can't otherwise afford it and who need this planning so much. So thank you for coming here. So I get to take you now on a tour of each of the most important planning tools that people diagnosed with dementia can have, or people who have a family history or a desire to do this planning in advance for this possibility. Many of my clients have had family members with dementia, and even though they're not diagnosed, they want to do this planning because they saw things that happened with their family member or loved one that they would want to avoid. So keep that in mind with this planning. So what's my teaching goal? My goal is to help you as possible future volunteer attorneys helping others do this planning, or as people who yourself may want to do this planning for yourselves and your other clients. My goal is to help you translate these documents for your clients in a way that makes them usable and understandable. Then I'm going to go through what information or choices you need from your clients or yourselves to draft these planning tools, and what advice you need to give your clients so that you get well-informed decisions and choices from them. So for each planning tool I'm going to talk about, I recommend that you talk to your client about each of the following things. First, what is this tool? Explain what it is in terms that the clients can understand. Most of my clients and my law students don't actually know what these tools do and even how they work, how you use them. So, and I've found that clients who've done these kinds of planning via LegalZoom and other sort of online sources, they often have no idea what they just signed. And our job as lawyers is to make sure we translate these documents for them so they understand what they have done and how to use the documents. The second, so what is the tool? The second thing, why are you recommending this planning to your client, given future possible dementia? And tie your recommendation to what your client's goals are. What are their goals? Why is the client, and one way to get at that is to ask your client, why now? What's driving you to do this planning? And that way you will find out much more about what their fears are, their hopes are, what they hope to avoid, or what they hope to have happen in the future. That's a goal or objective, not the name of the document, but what's driving them. And if you can tie your client's goals to the documents and planning you're recommending, that's gold. And that will make your clients very happy, and they'll understand why they're having these documents in the first place. So what is the tool? Why are you recommending it, tying it to the client goals or things they haven't thought about? And then if your client agrees, give advice and get the information and decisions from your client that you need to draft the document and fill out the toolkit form. So I'm going to go through each of these decision points as we go through each document. At the end of this presentation, we hope you'll have more confidence in your advice and representation of clients needing this really critically important planning. And if you're here to see if you yourself should do this planning, and I do hope you are thinking about that as well, that you'll know the answer and what decisions you need to make when filling out these planning tools. Okay, so you're at slide 19. Good. So here are the 4 most important planning tools for people with dementia that we will go over in more detail today. First, a durable power of attorney for finances. Second, a durable power of attorney for healthcare. Third, a healthcare advance directive, or what's known as a living will. And finally, the Living with Dementia Mental Health Advanced Directive. So those are the 4 big ones we'll talk about today. Next slide. All right, let's start with what I think is the single most essential planning tool for clients with dementia, and that is a durable power of attorney for finances. Why is this tool at the top of my personal list? Without having a financial power of attorney in place, a person with dementia faces almost certain financial disasters or disruptions that are expensive, could result in the loss of their own rights and loss of their choices. Virtually everyone with Alzheimer's dementia and most other kinds of dementia will lose at some point the ability to make financial decisions and the ability to execute those decisions. So they really need a trusted person to step in to make those decisions and to execute those decisions. So unlike the other planning tools I'll discuss today, there is no other way to get financial decisions made or executed in the law that automatically assigns someone this ability. For example, there's no informed consent statute that assigns medical decisions if there's no medical durable power of attorney or living will advanced directive. There is a statute that does that in Washington state. There's not one for financial decisions. Or there's no intestacy statute that automatically distributes assets if you haven't done a will. And no conversations with family members or loved ones about your financial values will allow them to actually make and execute those decisions on finances in your stead without this planning tool. So it's really a critical tool to get basic things done. Without a financial durable power of attorney, your client with dementia faces the real possibility of needing an expensive, time-consuming, and rights-removing conservatorship or guardianship filed against them in Superior Court in order to get the job done, even a simple job done. Clients with dementia often do not need or really want the high cost of a guardianship or conservatorship, which I understand is a minimum of $10,000, and probably more now, as others here can attest. That comes out of the client's own pocket. If they had this simple planning tool, a financial durable power of attorney in place, they often can avoid the need for any guardianship or conservatorship. So this document, this simple document, can save your client all of that trouble. Have I convinced you yet that the financial durable power of attorney at a minimum should be considered and perhaps in most cases be executed by your client with dementia? I hope so. Now look, and we can get this in questions later, there are definite downsides to a financial durable power of attorney. I'm not going to go into them at this point. I'm giving you the upsides and why clients often should and want to do this planning. So now let's go through how I would recommend explaining this document to the client, what it is and why you are recommending it. And then I'll go through the information you need to draft it and what advice to give about each piece of information so you can get a well-informed answer from your client. So first, what is a durable power of attorney for finances? It's a written document that gives someone else of your choosing client the ability to be you with respect to making all financial decisions and then executing them just as you could. It creates what I call a mini-me, an additional person to be you in the world for your financial affairs. You get to choose who the mini-me can be for you. you do not lose any rights to continue doing everything you already do yourself. You just duplicate yourself, okay? That's just an example of how I would recommend, how I explain the document. So why am I recommending that you execute a financial durable power of attorney? At some point in the future, everyone with Alzheimer's disease and most other forms of dementia will no longer be able to make financial decisions themselves or execute them. So what are the kinds of decisions I'm talking about? It's the things you do every day, every week, every month, every year. It's writing checks for paying your bills, for getting credit cards, for entering into contracts, for paying your rent or your mortgage, paying your utilities, your car payments, suing or defending lawsuits, filing your tax return, applying for public benefits, choosing which benefit plans you should have during open enrollment. Think, client, about all the things you decide and do on a daily, weekly, monthly, or yearly basis. How would you get these things done if you yourself can't do them? What will happen if they can't get done? And I talk to my clients about, the potential loss of a home for not paying a mortgage, loss of a car being towed, utility cutoffs, inability to choose a better healthcare plan for you during open enrollment. Those are all things that can happen if you couldn't transact business yourself. So here, the agent in the durable power of attorney for finances can step in to act as you would and avoid some of these disasters that can occur. How is it used? My clients often do not understand once they have it drafted, like what happens with it. So by your chosen agent, the person you choose to act as your mini-me, takes that signed document by you to the bank, to the grocery store, to credit card companies, to tax accountants, to your lawyer to defend a lawsuit. And they act as you, they sign your name as your agent, and it's done. So it's really an easy document to draft, and it's an easy document for the most part to use just by showing it and identifying yourself to the bank or the credit card company, et cetera. Now, assuming your client says, yes, I think I want this planning. What information do you need, and what advice should you give on each piece of information? So here are the critical questions in a financial power of attorney that you need to get from your client. Who do you want? Who in the alternative do you want to serve as your agent? What powers do you want them to have? When should it be effective? And who would you nominate, assuming that agent is your guardian or conservator, should you need one? Those are the critical questions and pieces of information you need. Now, I'm going to just go through my quick advice on the who and the what powers. So who should you choose as your mini-me agent in a financial power of attorney? Let your clients know this is the single most important decision they make in this planning. You want your clients to choose a person who they trust completely with their money, with their savings, with their home, with the things and financial things that are most important to them. Is this person good with money? Have good judgment, financial judgment, know how to keep records, knows your values around money and what you would do or what's best for you if he or she doesn't know what you would want in terms of how your money is spent and bills should be paid and what you should be doing. Those are the critical questions. Do they trust this person with their money? And the same is true for the alternate agent. It's really good to have an alternate. And I should say not all clients have agent, someone they trust in this way, and that's a very difficult situation. And not all have more than one person, but it's really helpful if they do, because if that agent isn't available or is, or dies or becomes incapacitated themselves, having an alternate can save them from having to do guardianship or conservatorship. Okay, so that's the biggest decision, and a good advice on that makes a big difference. So then the what powers? That's the second biggest decision the client must make in financial power of attorney. And really the issue is, should it be the broadest power possible or a more narrow power? The broadest power of a financial power of attorney is basically the ability of the agent to do everything that your client or you could do if you were physically present and signing. There are certain minor exceptions, but it's basically very broad. Everything you could do, all those things I pointed out that happen daily, monthly, yearly. A narrow financial power of attorney would be something like only pay my mortgage out of my credit union bank account every month. That would be a very narrow and limited financial power of attorney. Both of those are possible. So what's the advantage you could tell your client of the broadest power? If you give the broadest power, you won't forget anything that you might actually need done in the future. So let's say it turns out there's no lawsuit the client's defending or bringing now, so they think, why do I need that power in there? Well, what if it turns out you have a car accident and need to sue or defend a lawsuit for damages or medical malpractice? There are all kinds of things that come up in the future that we don't quite imagine today. Now, without that broad power, a guardianship or conservatorship would need to be filed just to get that power, that one power given, so that you can defend or bring the lawsuit. So that's the advantage of the broadest power, is just in case you forget something, you won't have to go forward with an expensive and time-consuming guardianship. Now, the downside of a broad power is it gives a lot of power that could be abused by the agent. So, people may be willing to take that risk of possibly forgetting a power because they just don't want to give that kind of power and access to their agent. So, and sometimes clients are just not comfortable, even if they trust the agent, of just giving broad powers. So keep that in mind. There are good reasons not to give the broad power, but there are also very good reasons to give the broad power. Let the client decide. The next issue with the powers in the document, is the special powers. The statute, the RCW 11.125 is the durable power of attorney statute, says that if you want certain powers, you have to specifically put them in the document, which means you have to talk to your client about these special powers, because clients wouldn't necessarily think of them when signing a broad power. That's why the statute specifies certain powers you've got to specifically put in. And those include gifting, changing life insurance beneficiaries, creating trusts, things like that. And I'm going to talk only today about the biggest one that you for sure want to talk to every client about, and that is the gifting power. So why have a gifting power? Why give an agent the power to give gifts? So the reason is, first, it would allow your client to give gifts as they have in the past. Would allow the agent to do that, like for birthday presents, for college funds, to charities, etc. Without the gifting power, that stops. And that may be fine. Your client may be fine with that. if they can't personally do it. What about, but one big reason for people with dementia to create a gifting power, even if limited, is to do long-term care financing planning. Everyone with Alzheimer's and most other dementias will need long-term care at home or in an adult family home, assisted living or nursing home at some point if they lose their ability to do activities of daily living. So they're going to need really expensive personal care at some point in the future. And unless the client has substantial savings to privately pay for that, or has gotten long-term care insurance that will cover it, most people can't for long afford paying for long-term care. And again, with Alzheimer's, we could be talking about a 10-year period or more of needing that kind of care. Medicaid is in our country the source of payment for most people who need long-term care funding. It's not Medicare. Medicare doesn't cover that. And gifting can be used in certain circumstances to qualify for Medicaid funding of long-term care and to avoid a lien on a person's home at death. And many clients want to be able to, pass on their home and savings, but to loved ones after they die. And a gifting provision to do long-term care financing and avoid a lien could allow that to happen. And so talking to clients about that is really important. And gifting power, particularly for people with dementia, and even if it's limited to just doing long-term care finance planning and avoiding a lien, that could make a huge difference in your clients, meeting your clients' goals and in their well-being and in avoiding a guardianship. All right, that's it. Oh, by the way, the downside of a broad gifting power is it's, you give a broad power and allow an agent to gift, it's a way that a lot of financial abuse can happen because the agent really has gotten permission to give gifts, even possibly to themselves without limit. And I know the prosecutors that do elder abuse and financial abuse, they often have come into my class and said, we don't like that power. So it's a balancing thing, but for people with dementia who might need long-term care and need help financing, it can be a lifesaver. So you can make it limited to that. Okay, let's go on now to, that's it for durable power of attorney for finances. Let's go to slide 21. Yes. This is the second big document. It's a durable power of attorney for healthcare. And it's the same or similar advice as a durable power of attorney for finances for the client, but you just don't need to give much advice at all about the powers part that you do as you do in the financial power of attorney. So first, what is this document? This planning document makes a person of your choice a mini-me for making healthcare decisions in the event you, client, are unable to make that decision yourself. That's what this document does. It gives someone else of your choice the ability to make healthcare decisions for you if you are unable to say what you want. So why do this, client? If you don't do this, and you can't make healthcare decisions at the time you need, for example, due to dementia at this point, then a statute, RCW 7.70.065, assigns those decisions to particular people, and you may not like who that statute assigned the task to. So who's assigned? First, a spouse or a registered domestic partner. If you don't have a spouse, then your adult children all together must unanimously decide on what to do. Then your parents, whether they're divorced or if you have good or bad relationship with them, then adult brothers and sisters, and then it goes down the line. Now, not everyone likes that list. And in particular, if there's not unanimous decision among a group, then you back into a guardianship situation. You don't go down the list. So this document, client, allows you to choose one person to make these decisions and alternate in case that person is no longer available. By the way, don't assume your client is happy with a spouse making these decisions. I have had so many clients, and think about yourself, a spouse or partner. Would you want them to make decisions? Some don't. They say, my spouse would never be able to, make decisions on my behalf because they hate the sight of blood. They can't deal with hospitals. They wouldn't be able to, turn off machines. They're too emotionally involved. So don't check that assumption that a client's spouse would be their choice. So assuming your client says, yes, I want one of these documents, what do you need? What information do you need? And what advice do you need to give? And here, again, the most important thing is who would you choose and who in the alternative would you choose? So here's my advice on the who. Choose a person who you trust with your health, a person who would honor your values around healthcare and make the decisions you would make, even if they wouldn't choose that decision themselves. For example, if they wouldn't choose removing life support for you, if they wouldn't choose stopping treatment for pneumonia when you can no longer recognize or interact with your loved ones due to dementia, if that's what you would want. If they can't do that, don't choose them. But if you think they could, that's the person who would follow your values. You also want someone who's very good in medical emergencies and in medical settings and can take in what medical providers are saying to you and who are not afraid of hospitals. Those kinds of, that's the right person. So make sure that person your client chooses has these qualities. And by the way, it's a very different qualities and skills than a financial durable power of attorney agent, right? Someone who's good with money may not be good with making medical decisions or be queasy with those decisions, or may be unable to execute something you would want due to their own emotional involvement. And vice versa, a medical agent may not be good with money at all. So make sure you check the qualities and make sure the client understands what skills and qualities the person should have. Okay, that's it in terms of powers. Let me just see for a second here. All right, so the other thing in terms of the powers in a healthcare power of attorney, you don't want to limit the powers and access to information of a medical decision maker, unless, of course, your client, let's say, is a Jehovah's Witness or a Christian Science and have particular medical issues that the medical decisions, and they want to limit power. But even that would be better placed in an advanced directive. So generally that you want to give full powers to a healthcare agent, unlike necessarily a financial power of attorney. Okay, on to slide 22. So we're now on to another really important planning tool that everyone with dementia should have in their toolkit. It's called the Living with Dementia Mental Health Advanced Directive. And this is one of my personal favorites I was involved in helping create this advance directive. This is not an end of life advance directive tool like the living will. It's about a planning tool where people with dementia can plan ahead for predictable decisions that almost everyone living with dementia will need to make during the long course of the illness. Remember, Alzheimer's dementia person can live a very long time, but have diminishing capacity over that time. So what are the sort of most predictable and plannable decisions that most are likely to come up with while living a life, a long-term life with dementia? These are the predictable decisions over the course of life that we have come up with. First, when to consent to virtually inevitable out-of-home placement in a nursing home, adult family home, or assisted living facility. So thinking about when you would agree to or not agree to go to that out-of-home placement. Second, how to pay for the high cost of dementia care, long-term care, without bankrupting the family. Third, how to handle possible future intimate relationships for the client and a partner. Fourth, when should your client decide they should stop driving, which is often the client's main source of independence. Getting a decision on driving while the client can still make it can really relieve stress for everyone. Fifth, how to deal with when a client with dementia who's never before been violent now suddenly lashes out and hits a care provider, a spouse, a partner. So how to deal with assaultive behaviors, wandering, and the possibility of involuntary hospitalization should the client need that. You can plan in advance for that. Sixth, when and if to consent to be part of scientific studies on Alzheimer's or other advances. So that's what this planning tool can anticipate in advance and give the client the ability to make decisions on while they can. So why would you recommend this planning tool? By knowing what decisions are most likely to come up in the future for clients with dementia, discussing them with people that the client loves and trusts, and making those decisions ahead of time while able, your client can have a voice in their care, maintain self-determination, and ease the stress and guilt on family members and caregivers who otherwise must guess what the client would have wanted. This really relieves stress for the client and for their caregivers and loved family members. So this is a long document. Clients don't have to deal with every part of it if they're not comfortable with it. I mean, there's questions about future sexual relationships and, some very difficult topics. But I have found, and this is my experience with clients, with families, members, with friends who have completed this planning document, that it is a huge relief to do it. And that they, in fact, were very happy to finally have discussed and thought about in advance these really difficult decisions that they may not have thought about before. And so while it can be difficult, it often can be very rewarding and a huge relief. So we have given you a link to the Living with Dementia Mental Health Advance Directive, which I've created with End of Life Washington, the form and more detailed instructions on how to fill it out. So I highly recommend this for anyone with dementia or with a family history of it. Okay, on to slide 23 and 24. And now we're going to talk about our last but not least planning tool, the Advanced Healthcare Directive. This is what clients have heard of as a living will. So what is it? This is a document that is you or your client's direct voice in the kind of care you, the client, want at the end of life, or if in a permanent coma. And it also allows you to express your general values around healthcare and quality of life if the client has a serious but non-terminal illness or a sudden injury that is not going to get better, but it's not terminal and you're not in a permanent coma. It allows you to express your healthcare values in advance. So do you want machines keeping you alive if you were never coming out of a permanent coma? Or if you were terminally ill and near death and only machines for breathing, nutrition, and fluids was keeping you going? Or if you have a permanent illness or disability that you're not going to recover from, what kind of care would you want? What are your values? Why are we, that's how I would explain it. Why are you recommending this? It allows the client in their own voice to decide what they would want. It relieves family members and loved ones and agents, healthcare agents, of making these very hard decisions without the input of the client with dementia, who can't say now what they would want. So it's really powerful. So what are the decisions, the standard decisions that are in a living will healthcare advance directive? First, if you are terminally ill or in a permanent coma, and the clients often don't understand that it's a permanent coma, meaning it's one that you're never getting out of. I've had clients come in and say, well, I was in a car accident a few years ago, and I'm really glad I didn't have this living will because I was in a coma and they would have let me go and I came out of it. Well, that's not what this applies to. It only applies to permanent comas where two doctors are saying you're never coming out. So let clients know that. It's a big misunderstanding about this document. In that case, do you want feeding tubes or IV fluids or ventilators to keep you going? And we're not talking about ice chips or comfort care or pain relief. So it's really important to explain that to clients. And most clients want that, don't want artificial prolonging of life. Once they know we're not talking about hand feeding or ice chips or comfort care. Okay, let's go on to the next slide. Yes, so now this has to do with the additional instructions that you can put in to an advance directive, and I highly recommend you do this. These instructions go beyond what the terminal condition or permanent coma situation, which are very rare. Most people never are in a permanent coma or terminally ill, right? But they still have care standards or care values that they want implemented, and particularly for people with dementia when they can no longer say. So that's why you can put in more than the standard answers here. And this is where your clients can talk about their values, their fears, their hopes, that they can apply to all kinds of medical situations. And people with dementia are not in a permanent coma, or it may not be terminally ill, meaning near death. It's a terminal illness, but it could be 10 years out. People with Alzheimer's can live for a decade and more. Your clients may want to decide to stop treatment under certain conditions that they can state in this part of the planning tool, in the additional instructions. So go to the next slide. Yes, the next one. So what I would recommend that to figure this out with clients, that you talk to your clients about at least these 4 topics. First, what makes life continue to be worth living for you? Or is life always worth living? Second, what hopes do you have for your care and quality of life? Third, what things do you want to prevent or that you're afraid of happening? What are your fears about your future care? And fourth, what's your preferred environment or care setting at end of life? These are like 4 big areas, topic areas you should cover with clients that you can draft into the additional instructions. So what can you ask your clients to get at these issues? What would a good death look like for you? What are your fears about the dying process? Are there certain things you do in your life that, if you could still do, would make life worth living? For example, my father-in-law said, if I can still play bridge, then life is worth living. I've had other clients say, if I can watch the Mariners play, then I want to keep going. Others have said, if I can read, life is still worth living. That's enough. And then conversely to ask, what if anything makes life no longer worth living? We've had clients say, if I can't be outside at all, I'm ready to go. If that permanently, I'm never going outside. Or if I can't, people with dementia have said, if I don't respond to or recognize my spouse or partner or my loved ones, I'm not consistently not recognizing people, then I'm ready to go. Or some clients will say, nothing, I believe in miracles, life is always worth living. You can say that in the additional instructions too. The other question I would ask is, where do you prefer to spend your last days? Do you prefer to be at home, in a hospital, in a nursing home, hospice, or is anything that your family members think is right for you or decision makers, is that good with you? So by drafting these kinds of simple instructions on fears, values, hopes, quality of life, that can give great guidance to family and care providers about what your client would want. And I really recommend you ask these questions. Okay, so on to the final slide 27. What about once you've done the drafting with your clients of these documents, what should they do with them? What's the final advice? You want to tell them who should get copies of the documents, who should get the original, make sure they understand what each document does, who they appointed, and how to revoke each document. It's really good to know these are not permanent decisions. You can always revoke. And in the materials, I've given you a sample closing letter with advice on each of these topics that we can give our clients, because they're not going to remember anything much that you tell them orally at the time they're executing the documents. So I recommend that you put it in writing, and I've given you a sample letter to help draft that for clients. All right, so that's it for my part. I really recommend, I'm so happy you're considering doing this planning with clients and for yourselves as well. It's really important. And if you give them what it is in a way they understand, and what information, why they should be doing it, and give them advice on each of the pieces of information you'll need, they're going to be very happy. If you tie it to their goals, you're going to be doing a great, as we call it, mitzvah. And here on Valentine's Day, there's not a better time to do it.
Great. Thank you, Professor Brodoff. We're lucky to have such a knowledgeable person to explain this to us. I'm going to go over now just a couple other documents that we're not really covering, in depth today, but I just want to make sure that they're on the radar and that you're aware that they exist. Clients may come in and have questions about them. The first is the Mental Health Advanced Directive. And that's different than the one we were just talking about. This one sets out choices so people with mental health situations can provide authorization for health decisions if they're experiencing times when they can't do so themselves. So that's one you might see or hear about. The other is the POLST, or a POLST. And this is actually a medical document, a physician's orders. For instance, if under no circumstances a client wants CPR because of age or some sort of medical condition. This is like I mentioned, this is a medical form, so I would encourage you to tell your client to talk to their doctor about this. And the last document is a disposition authorization for in Washington, we can decide what happens to our bodies after we die, or at least who makes those decisions. And so completing one of these can set out what happens and who controls that process. This can be very useful. There's a lot of family situations where family members may not agree what should happen after death. So another document to have on your radar. And then finally, more resources. Obviously, if you haven't seen Washington Law Help before, you should check it out. They house the forums that we use for our clinics and our dementia legal planning volunteer opportunities. And hopefully you'll volunteer with us. And if you do, we'll make sure to send you all the documents you need. And so you won't need to go and look them up yourself. But I do want to point out Washington Law Help because they have things in all sorts of different languages. So this can be really helpful, and not just for the documents we talked about today, but for all sorts of things. I believe the website's going over redesign right now, so it may not look just like this, but they do have a seniors section, which covers all sorts of useful documents, including these ones. Community Living Connections is a great resource, memory loss info.org. There's a lot of community resources and social service resources there. And End of Life Washington, also, like we mentioned earlier, is where they house the Living with Dementia Mental Health Care Advanced Directive. And there's also information here about death with dignity and other things. And finally, I will mention the Washington Will's website in a pinch. If you have a client who needs a very simple will, I think it's a fine resource. I will note that we do work with 16 volunteer programs covering almost all of Washington State. And many of them offer wills clinics or can offer a consult to a low-income client. So I would suggest also reaching out to any of the volunteer lawyer programs, or even the CLEAR hotline through which clients can be routed to the volunteer lawyer programs for things like simple wills. So that's all we have. Thank you very much. We do have a little bit of time for questions. I see Caitlin has dropped the feedback and CLE credit form into the chat. We'll send a follow-up email with that link as well. But if you would like CLE credit, or rather if you would like us to make sure to submit the request for CLE credit for you, please make sure to fill that out so that we have your information. And let's see, I see Professor Brodoff has already jumped ahead of me and gotten most of the questions in the chat. Yes, and Milena Pinkham asked, are these forms getting emailed? Yes, we will make sure to email these all to you following this presentation, along with some with the video as well.
Can I make a mention about the forms in particular? Well, all the forms that I discussed are being updated right now. I'm working with Northwest Justice Project on this, and a very significant, and I think, improvement in the Living Will Healthcare Directive, where those, 4 questions that I suggested you ask are embedded in the form in a way that will really help you generate the documents for the clients. That'll be really useful to them to getting the healthcare values. And that should be, probably in the next, few weeks, we're going to have big improvement in that area. So hang on to that. Hang on for that. I'm very excited about that work.
And we will make sure to get those new documents and incorporate them into our materials for the Dementia Legal Planning Clinic also. So we'll update those once we get them. And let's see. So I'm getting a lot of kind of technical questions here. Can we access this recording to share with the spouse? Definitely. Once we have this recording, we'll download it and we'll post it up on our website. We'll send that link out. And that should be within the next day or two. I see a question. Let's see, Professor Brodoff, do you see this question from Rhonda Larson?
Yes, so the question has to do with that the new, whether gifting power, whether you really need to have a gifting power for Medicaid planning, for long-term care planning. And you correctly point out that the statute allows it for transfers to qualify for Medicaid, but I would still put the gifting power for long-term care planning in there, because the statute doesn't say anything about gifting to avoid the lien, the Medicaid lien, which is a very big part, and clients want to do that. And there is gifting that can avoid the lien, so saving the home. And the statute doesn't specifically talk about the lien. So I just put it in there to make it clear anyway that that was the client's desire, right? And I wouldn't rely on the statute for that unless you had to, right? Unless it was after the fact and you needed to do some gifting. But it doesn't talk about the lien, so that's why I specifically talk about the lien in our drafts.
Thank you. I think we're coming right up on time now. So if you have any other questions, you can contact Caitlin or myself at the email on screen, or go to probonocounsel.org and you should be able to contact us that way. Thank you so much, Professor Brodoff, for the presentation. And thank you everyone else for attending. Have a happy Valentine's Day.
Good to see everybody.